So today we're going to talk about more of the intricacies on the different business structures that we've mentioned. We've decided that we need limited liability for our business. We're going to go ahead and form something with the state. And so we're going to try to figure out what that is. We try to figure out if it's a corporation or an LLC. We're going to focus on where to form a business, why that's important based on the structure, how to go ahead and form that business, what's really needed, what else is needed that's not necessarily required to form it with the state? And then when do you do this? And so we've been thinking about the business structures in the context of a problem that I have of not having time to do laundry. And so I've come up with two different business models, you wash and we wash. You wash, perhaps a close location to wash my clothes would be convenient. And so this is going to have physical assets. It's going to have a brick and mortar location. It's going to have some short-term cash flow. And then an idea that I like much more is WeWash, maybe a mobile application that in which drivers can pick up clothes, bring them back to their homes, use their washers and dryers, clean the clothes, and drop them right back off to the customer. So it's going to create a two-sided marketplace in which those contractors can go ahead and actually make some cash with their laundry equipment. And so the first thing we're going to talk about is where. Where are we going to form each of these businesses? We've decided that maybe WeWash would fit better within a corporate structure, and UWash is probably a little better for an LLC structure. And so where? And why does it matter where? Isn't it just where you are? No. Well, it's actually not. So it's basically state law governs the relationship between the various stakeholders that are involved in a business entity, and the actual relationship between those stakeholders and the business entity themselves, or the business entity in its relationship with other business entities. And so we're going to look and answer those questions in that context. And so we're talking about WeWash. We've said that WeWash is going to be a corporation, WeWash Inc. And believe it or not, we're going to form WeWash Inc. in Delaware. The major reason is that Delaware has spent a lot of time and money on their statutory law, which is their written code, their written business code. And so as a part of that, other states have tended to follow Delaware's code, how they've designed their corporate structure and their corporate code. And what that has done is it's created a lot of different entities that have been formed in Delaware. Most corporations, large corporations, are formed in Delaware. And so whenever there's disputes on the statutory language, the interaction between the stakeholders and the actual entity itself, the Delaware courts have been designed that create a very specialized business court that can answer the questions that arise and the nuances that come up in the statutory law. They also have a very sophisticated, fast, and convenient Secretary of State that hosts most of their filings online, and the clerks are very knowledgeable. So this has led lawyers, especially corporate lawyers, to really know and understand the nuances of Delaware law, which actually has importantly also created a little bit of a standardization, which a lot of venture capital firms and investors tend to rely on Delaware law and look for their corporations to be organized or incorporated in Delaware. And so conversely, when we're talking about UWash, we have a much more local business. So we don't really need to be focused on a standardized law. Most of our stakeholders are just going to be in one state anyways. And so when that's the case, we're generally going to form this LLC in our home state, where our employees are, where we are, where the brick and mortar location is. And this has the benefit of avoiding some unnecessary business registrations in other states. We're only operating in one state, so we don't really need to register in a bunch of other states, which we might need to do if we're a corporation and we're operating outside of Delaware. Now, this is just a general rule. If an LLC is operating in multiple states, or it's maybe UWash is under a franchise model or some type of operating in numerous states, and they get some investors, then they might want to look at Delaware as well, just to deal with the standardized approach that Delaware provides. So let's go back to corporations here. Let's talk about WeWash. What do we need to form WeWash with the state? Again, we need to file something with the state in order to get that limited liability protection and in order to actually incorporate and form that business. So we're going to file a certificate of incorporation, which is often called the charter. The charter is going to have a few things that are going to need to be listed, including the name of the business. So we went with WeWash Inc. What's important there is that we would want to check in beforehand and make sure that WeWash was not taken, that there's not another business that's operating in Delaware or formed in Delaware that is named WeWash. And we're also going to want to make sure that we have the right ending, right? We can't make it WeWash LLC because we're not an LLC. We need to make it WeWash Inc., WeWash Corp., WeWash Corporation, or some variation there. You're also going to need to list your authorized shares and your par value. So authorized shares is basically the maximum amount of shares that you can offer and sell or give out to the stockholders. Usually I do a very, very large amount, like 10 million. And what that basically means is that from this list of authorized shares, from this amount of authorized shares of 10 million, I could issue maybe 1 million to the founders, to Adam and to Betty. And then I could reserve maybe 500,000 to employees. So I have enough to kind of keep me in place. And so when I give those shares out or sell those shares, those are issued shares. So if only 2 million are issued, then I still have 8 million of the authorized shares left to issue. So there's a difference between authorized and issued shares. Another aspect of shares of stock are par value. Par value is the minimum amount that you can sell those shares for. Usually this should be a fraction of a penny, maybe a quarter of a penny. And we'll go over in some other videos why, but generally when the stockholders buy or receive their initial shares of stock, they're going to pay par value because the company doesn't really have any value yet. It's just been formed. And so you're going to want to make that cost very, very, very low. The third thing that you'll need is to register a registered agent in Delaware if you're not located in Delaware, which most companies are not. So you'll have to appoint a registered agent. Usually it's going to be about $50 a year to appoint a corporate registered agent in Delaware. You're also going to need to form an EIN, and if you're operating business in another state, then you'll need to register and qualify to do business in that state. Basically, those states want to make sure that they are receiving the appropriate taxes and fees that are associated with actually operating business there. So one thing that we didn't really touch on, but tends to catch some founders a little bit when they receive their first Delaware franchise tax bill. We talked about making sure that we have a large number of authorized shares because we're going to have investors, we're going to have employees, we're going to have a lot of folks that are going to want shares, and we're going to want to give out a lot of shares. It sounds much better to own 1 million shares than 10 shares. And so we're going to want a large number for various reasons. But the default method of calculating a Delaware franchise tax is tied to the number of authorized shares. So if we have a lot of authorized shares, we're going to have a huge tax bill. Except there's a different way to calculate the tax that's owed, and that's called the asset-based method, where you can include your assets in your filing, and if it's lower and you don't have a ton of assets, then your tax bill will be much lower. It's kind of a trap for the unwary, so when you go to check that tax bill, make sure you explore the asset-based method as well. So the articles or the certificate of incorporation, the charter, were what we needed to file with the state. Now, there are other things that you need with a corporation that aren't included in the filing, that do not go to the state, but are kept in the books and records of the company. These include the bylaws. The bylaws basically set out the rules and the roadmap of how the company is going to be operated. So, for instance, it might say that the annual shareholder meeting is on this date, and this is how it's going to be conducted, or the board of directors are going to be comprised of nine individuals. It might say how the stock certificates are going to be kept. It's going to include the mechanics of the corporation, and it's generally standardized. The resolutions, when you form a corporation with the state, you're going to need to initially ratify the actions of the person who incorporated the corporation. You're also going to need to appoint the board. And so you want resolutions, which are similar to meeting minutes, or they can be an action in writing, to approve the board. And then in turn, the board will act with its own resolutions to appoint the officers, to sell shares of stock, to authorize, the approval of a bank account, and various other kind of corporate matters that you need. And so we're also going to need to issue stock. Often this is through with companies that are planning on being venture-backed or high-growth, high-scale companies, includes restricted stock purchase agreements, and we'll discuss those more in other sections. Stock certificates. You're going to need to have stock certificates. However, often most companies, especially high-scale companies and modern companies, are not actually printing out and issue stock certificates anymore. Instead, they include some in their resolutions and in their bylaws that instead they're just going to keep the ownership of shares recorded on the books and records of the company. So you might have a cap table or a ledger or some type of recorded record of ownership. The last thing you're going to need, and we're going to spend a lot of time on this in another section, is to make sure that the IP and the technology that's been built prior to incorporation is affirmatively transferred over to the corporation itself. Let's go back to an LLC here. Let's go back to UWash. What are you going to need to file in your state? You're either going to need articles of organization or a certificate of formation. There's variations based on the state, but those are basically the equivalent of the charter, and they're going to require similar information. You're not going to have shares of stock, however, so you're not going to need to include par value or authorized shares. Instead, you might need to disclose your management structure. Will it be managed by its owners, or will it have its own structure where it's managed by its managers? You're also going to need an EIN, which is just the tax identification number. And you're also going to need to register in other states if you're conducting business in other states. Let's go to the non-filings. So this is really the bulk of an LLC. And this is where I often hear people say that LLCs are cheaper and they're a little less expensive, a little less onerous. And that's not really the case when you take into account the operating agreement. So the operating agreement includes all the bells and whistles of running an LLC. And if your LLC is just one owner, the operating agreement is going to be relatively short. It's going to be relatively standardized and relatively easy. When there's more than one owner, it's going to be a little bit more difficult. When there's different managers, it's going to be a little bit more difficult even still. The operating agreement, it can be lengthy. It could be 50 pages long. And why? Because it's going to include the ownership, how the company is owned. It's going to include like a cap table. It's going to say what rights do you get associated with ownership, what type of rules are in place for transferring your ownership. You obviously, if you're in business with somebody, you might not want them to transfer their ownership to their neighbor because you don't want to work with their neighbor. You're working with them. Also, some buy-sell events. So let's say one of the owners goes bankrupt. You wouldn't want the bank to be able to take those shares and also own and run the business. So there's going to be some buy-sell triggers that are going to be involved in an operating agreement. Basically, if these events happen, then you're going to need to sell your shares either back to the corporate, back to the LLC, or perhaps back to the other owners. Management and voting rights are going to be included in there, very detailed and specific to what the LLC is looking to accomplish and its governance structure. It's also going to include a lot about tax allocations and distributions. So when you're an LLC, unless you affirmatively choose to be taxed as a corporation, you're going to be subject to partnership tax, or if you're just a sole owner, you'll be a disregarded entity. And so there's a lot of these different tax allocations that are set out in there, and tax rules associated with partnership tax, and then distributing profits and losses amongst the owners. And there's different ways to do this that are can be very complex. Lastly, you're also going to want to cover confidentiality and IP, making sure that everybody keeps the confidential information, proprietary information under seal, and that the intellectual property that's created as a part of this business is transferred over to that LLC itself. So when do we go ahead and do this? I mean, I've already been operating my business. Do I need to go do this now? Should I have done this before? You're generally going to want to form either a corporation or an LLC. Because of limited liability, you're going to want to get that in early. And so you're going to want to do that when you're starting to operate your business, when you're developing intellectual property or acquiring assets like a washer or a dryer. When you're entering into contracts, you're going to want the LLC, the corporation itself, to be a party to those contracts and not yourself personally. As we discussed with limited liability, what can happen there? You don't want your assets to be on the hook. And when you're hiring employees. So it's better to kind of get in front of these things and to form these business entities early on in the process. And so that's a little bit of the nuts and bolts on how and where and when to form a business entity. And so, until next time, venture awaits.